Welcome to the Business Law, Estate Planning, and Estates Podcast.
Hey everyone, welcome back to an all-new episode of the Business Law, Estate Planning, and Estates Podcast with attorney Thomas LaPorte. I am your host, Mike Leon. Thomas here is the founder of LaPorte Law Group, PLLC, with an office out in Portsmouth, New Hampshire, and a location as well in Andover, Massachusetts. And with more than 30 years of experience in this space, he's been helping individuals, families, and business owners protect their assets, plan for the future, and navigate estates and business matters with clarity. Today's episode, we're going to be talking about what business owners should understand when they're preparing to buy or sell a business in either New Hampshire or Massachusetts. Thomas, it's good to see you as always. So when someone comes to you and they're looking to sell, right, or maybe buy a business, what's the first thing you start to look for to kind of understand how prepared they are for this process?
Well, thank you for having me, Mike, and good to see you. Good question. The first thing I ask is, are you buying or are you selling? If they're buying, I want them to buy assets. I do not want them to buy, in general, stock or the company, because one is not only acquiring the assets and the stock, but you are also acquiring and being assigned any liabilities that may be existing with the company you're acquiring. Of course, if I'm selling, I represent a seller. I want them to, as much as possible, rid themselves of any potential liability. There may be an employee claim that's brewing. If there's any mechanics liens, which is another type of liability for work that's done on a real property, for instance, that houses your building, I'd rather that the person, if they're buying the building, they now take on that obligation. And of course, they, as a buyer, need to be diligent and ferret that out. And most of them are represented by their own attorney, so they've got to do their due diligence. Other than the distinction between selling a company and or, if you're a buyer, acquiring assets, which is preferable with small to medium businesses and the 3 states I'm practicing in, one should be prepared to present, if you're the seller, and to review and investigate with an accountant, if necessary, the profit and loss statements, the income and expense statements, otherwise known as company financials, for the last at least 3 years. And depending on the business or the sector, one may want to go back further. Back in the days of COVID, those years were anomalous. So we want to go back prior to COVID, then after COVID, to get a litmus as to how the business was growing or not growing. Within those financials, if one's acquiring or selling, you want to focus on or feature what revenue streams of the business are the best, what can be improved, what can't be improved. Good business people will look at the overall package, like they're buying an outfit or they're selling an outfit. You want to accentuate, if selling, the beautiful buttons on your jacket that may or may not be there. Other than that, as far as if I'm the buyer, I want to make sure there's no past tax liabilities. I want to look at corporate income tax returns, to make sure that all taxes have been paid. As part of a negotiation, the contract will include a non-disclosure clause, of course, for the party that is investigating the business, but also this should be involved. The buyer should also require that there's a covenant and warrant by the selling entity or company that they are providing all and plenary information. Because if they don't, and there's something hidden that's not found in the course of due diligence, sometimes takes up to 90 days, sometimes it's only 30 days. Depends on how motivated the parties are and what type of business it is. You may have a claim if something's omitted that based on fraud, basically, misrepresentation by omission. Companies that have works in progress, like insurance companies, roofing companies, construction companies, you'll want to find out what the nature of each of those contracts are, where they are in, say they're building something, where they are in a certain project. Are they on budget? Are they not on budget? Are the clients paying? Another thing to look at is, of course, your payroll records. If there's an HR department, and you want to present these too as a seller. If you've got your ducks in a row, all of these items in a row, your taxes, the contract records, your payroll records, and personnel records, you want to say, here it all is in a silver platter. It just makes you look so much more presentable. And a good advisor, whether it's an attorney or a business broker or an accountant that's helping you to bring this deal to fruition or even structure it, should be telling you about that. So one other thing too, if they have, as far as payment or the revenue streams, are there accounts receivables that are old and aging because you were buying those as well? Sometimes, and I'll finish here, well, not sometimes, more than often, the buyer will want to consider a holdback or a contingency. It could be for people that cancel their insurance policies before the year is up, or they don't pay their premiums for the whole year if they're on a monthly premium cycle, or folks that don't pay for work that's been done by the selling entity, and you get stuck. You paid X amount for that business, including that patronage, and you get stuck not getting revenue for that. Hold back a 10% contingency. We just recently did that with a company, and we almost nailed it to about 100%. 100% of the holdback, which is about $15,000, just a small roofing company. We had about $14,900 in work that needed warranty work. So the seller paid for that because they did the work. It's things like that that should be thought of and organized.
Thomas, let me stay on something that you mentioned before about contracts, because businesses do have long-term contracts with either vendors or landlords, customers. So talk a little bit more about how how do these existing agreements kind of affect the purchase of a sale or sale of a business?
It's an excellent topic you bring up, Michael, and I'm glad that you did. If the business that's being acquired is subject to a lease, well, that lease is necessary for the business to be operated. So the buyer must find out if that lease is assignable, must find out from the lessor or the landlord if that landlord is going to accept that new tenant, which is acquiring the business. The business and real property are separate. So that's an excellent point. And your point also goes to vendor contracts. So if you've got equipment, hydraulic presses, printing presses, whatever it may be, and you've got service contracts, most of the time they are transferable, but you've got to make sure that they are transferable. If they're not, if the lease is not assignable, or if the service or vendor contract is not assignable, you can often go to the landlord or to the service company and negotiate that. And they may want to have a new deal with you, but those are all important things because they add value. They are part and parcel of the company that you're buying. So those you need to have continuity with those, either by way of assignment that's already pre-approved, or you get the approval, or you sign a new contract that's acceptable to you. Customer agreements. Oftentimes, customers hire businesses for the commodities or products that they purchase. They want to purchase it from Michael's company. They don't want to purchase from Tom's company. Maybe they do. You got to make sure that those customer contracts, they're also called production contracts, needs contracts, is different names, that they will be accepted by the people that are paying your revenue, that they will accept the product or service from, if I'm buying Michael's business, that they're going to accept it from Tom and his crew as well. So those are very important items you brought up.
Yeah. Well, I mean, it's kind of what you said about getting your ducks in a row. And one other thing I'm sure will throw a monkey in the wrench there, if I said that phrase correctly, is, let's say one buyer, seller, they're in different states. Well, I mentioned in the intro, right? New Hampshire, Massachusetts. What are some additional legal factors involved there if the buyer and seller are in different states?
Well, you've got the parties have to decide on what state is going to govern the transaction. If there's a dispute over the transaction, which court is going to hear it? There is a slight, even though courts like to deny it, there is a slight home field advantage. So if I'm coming from Massachusetts, I'll want Massachusetts courts to be the forum and the law that's applied to the contract. There's a little bit more consumer protection, even though businesses are not really considered consumers in most instances, but uh, that exists more so in, say, a more laissez-faire, caveat emptor state like New Hampshire. Taxes are different, so I guess that's more akin to where you're operating the business. But as far as uh, what laws are going to govern the transaction, if I'm buying, Michael, your company, and I'm coming from New Hampshire, and you're in Lowell, Massachusetts, for instance, a new report, you have employees. Well, I bet to make sure I know, with help or through my own investigation, what are the rules that apply to employees in Massachusetts. They are far, 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 far different and strict, with stricter penalties if wage acts, for instance, are violated. You want to make sure, if you're just like anything else, what the laws are that apply to the various aspects of the company that you're buying, whether it's tax law, employee law, are the licenses required? Is there regulations that are different uh, that you may not know about? Because I've been in New Hampshire, but Massachusetts has this regulation, this reporting requirement. So those things have to be sifted out, sorted out, written down, and addressed
Yeah.
beforehand.
It's a lot. And let me ask you, you shared a mini example at the beginning, but without sharing obviously intricate details, names, is there a situation that you can recall where a business transaction kind of seemed straightforward at first, but then maybe a detail came out later and required the deal to kind of slow down or maybe shift?
Yeah, I can think of two. One involved the acquisition that did not go through. I represented the acquiring company, and it had to do with architectural contracts, just like a construction contract, although, albeit the company that was selling its assets and transferring its employees, I just use that word generally, uh, kept avoiding and evading our inspection of their hard drives, which contained a lot of the data on the ongoing works in progress, the payments that were being made on the architectural projects that the selling company had, raised big red flags. In addition, they wouldn't give us bank data. Uh, we found out that there was an outstanding loan to a Western Massachusetts bank that neared $1 million. That was not disclosed. And they had, in order to secure a payment of that loan, they had a security interest on the receivables of the selling company. So, and they were in default. So we just walked away from that. That was a pretty ugly situation. A smaller, not so difficult situation involves representing the seller this time. And the buyers, shrewd as they were, said that, well, based upon your income tax returns, and this is retail, and there are businesses that only report some of the income. My seller had a deli that was separate from the rest of the convenience store. Well, the deli was the high profit area, but the buyers wanted to focus just on the revenues and that were reflected on the tax returns that didn't include the deli. So there was a big fight over the price and the value of the business they were acquiring. We eventually worked it out with a sort of a licensing agreement where they share the revenue from the deli. But those are a couple of examples of unexpected events that arose in a buy sell situation of businesses.
One thing we haven't talked about, Thomas, is employees that work at these companies. Like, so the deal involves employees. What should both sides kind of understand about transition, responsibilities, employee agreements, and how that fits into the overall sale?
If I'm the acquiring company, I do not want to unwittingly take on any wage act violation in any state. There are penalties. In Massachusetts, is automatic triple damages plus payment of attorney's fees. They don't care if you unwittingly brought these employees on and the violation was a predecessor employer. There needs to be a dividing line whereby, like when someone's buying a real property with tenants, you get estoppel certificates from the tenant saying everything's good, there's no problem with my premises. You make sure all the lease payments are paid up, the landlord's not in default with maintenance. Same thing with employees. Identify who you want to keep. You send out separate offer letters to those employees so that they know they're being employed by a new company. It's a brand new relationship. Ergo, the new employer is not responsible for what might have happened in the past. The selling company has to be on board with that, and they are going to terminate the employees that you've chose not to continue on with your new company. You've got to make sure that the selling company, and the selling company needs to do this too for its own benefit, that everything that is owed to those employees that are not being retained and are being discharged are paid in a timely manner. Everything that they are owed, including vacation time and PTO time, that could be a big problem. I'd like to get written acknowledgments from the employees. They don't necessarily by themselves inoculate companies, but similar to an estoppel certificate, they say, I've received everything I'm owed, I've on time, I have no problem. So at least you've done, in some states, there are business exceptions to the Wage Act violations, good faith exceptions. So those are types of things that you need to do when determining, when dealing with employees who may be transferring over to a new company and those who aren't.
Right. Thomas, as we wrap here, that owner who's listening to this, they're thinking about buying, maybe even selling their business in the next year or two. Give them some practical steps that can help them kind of get ready long before they even sit down with either a buyer or a prospective seller.
Well, I think in order to be attractive and to appear professional and to be professional, I would get, if I'm a business owner and if I don't already have a good accountant, and interview a couple for their experience, for their rates, whom they've worked with, and get your financials in order. Make sure that hopefully your tax returns, if you're a restaurant, make sure your meals tax returns have been filed and you're paid all the meals tax. That's a big problem with restaurants and bars. Have them prepare a profit and loss statement for you. Have them prepare income and expense report for you, and have them do that for the last 3 to 5 years. That's going to show the history of your business, its trajectory, up or down, it's trending water, so to speak, but here are the reasons why. I would get those together, and if I'm a buyer, I would expect that those be ready for me to show that I'm dealing with someone who knows how to run a business. Therefore, the business I'm taking over, its patronage, is going to hopefully continue because of the business practices. So the financials, as well as payroll records, the employee files have everything they need to have in them, things of that nature. There's more, but that's where I start.
Right. Well, they can reach out to you to find out more. Thomas, it's good to see you as always. Thanks for the time and the insights. I appreciate it.
Thank you, Mike. Take care.
And thank you to everyone out there for listening to this installment of the Business Law, Estate Planning, and Estates podcast. If you want to learn more, like I mentioned, you want to connect with Thomas and his team over at LaPorte Law Group, do me a favor, visit laportelawgroup.net. One more favor before you go, hit like, hit subscribe, leave a review, comment, share the episode with that business owner that's thinking about selling that business. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.